What's up, everybody? Welcome back into another episode of The Lawyer You Know. We are going to break down the newest Karen Reed document, which is a notice from the judge to Alan Jackson and the other attorneys to show up to court. What are they going to talk about? And she even references a transcript she wants a copy of before this hearing because she needs to read exactly what was said. We're going to watch that hearing together and break it down and compare it to what was said in the prior hearing to see how much hot water is this defense team actually in. So the first thing we're going to do is read this notice. If you can't read it, don't worry. I'm going to read every word of it here on the screen. This is a notice to appear for continued hearing. On February 25th, 2025 at 11 a.m., the court will reconvene the hearing that began on February 18th, 2025. Counsel should be prepared to address the issues related to the defendant's recent production. The defendant's recent production, not production by the federal government. That's important. The defendant's recent production pursuant to Rule 14. So they produced it pursuant to the discovery rule, especially as the materials produced relate to prior representations made to the court on the record by defense counsel concerning the ARCCA witnesses. So that's incredibly important because that's what this is going to be all about. Especially as the materials produced relate to. So this is what we're going to continue this hearing on. This is what the new information given to the judge by Hank Brennan. This is why she left. This is why she cut off the hearing. It is the materials produced relate to prior representations made to the court on the record by defense counsel concerning the ARCCA witnesses. So it's specifically about ARCCA. It's specifically about statements made by defense counsel to the court. In addition, and here's something that's interesting, because the Commonwealth referenced a transcript of a hearing on June 10th, 2024, at the hearing on February 18th, 2025, the Commonwealth is to provide a copy of that transcript to the defense and the court by close of business on February 21st, 2025, which is tomorrow. So she said, you guys reference it. This is when you said, I'm the gatekeeper. It doesn't really feel like you're giving enough information. Are you really going to put witnesses on the stand without prepping them? Well, let's hear what happened in that hearing in its entirety, at least the parts that deal with ARCCA. And guess what? It's only about 4 or 5 minutes long before, of course, the mics went out in the courtroom as Lally gets up to just say something at the very end of it, but that's okay. We're going to watch it here together, the 4 or 5 minutes of this hearing to hear exactly what defense counsel said about ARCCA. We're going to skip the beginning part, skip when they talk about other experts because they were discussing other experts as well. This is when Yannetti got up and he said, I am mortified about what the Commonwealth said. And the judge is like, there's no jury here. Can we just get to it? He's like, Judge, I need to argue the way I want to argue. But eventually we get to ARCCA specifically, and here is the exchange. This is, by the way, June 10th, 2024. And if you remember, we're going to reference Hank Brennan's timeline of information because the only thing they had before June 10th was a March of 2024 email exchange where they said, like, pursuant to our conversation, here's a retainer. Tell me how much I owe you. And then ARCCA's like, hey, the U.S. government said we got to pause this. So that was the only communication we had beforehand. No evidence of any prep. Sure, you can say, well, they said pursuant to a phone conversation. They could have prepped on the phone conversation. Fine, but it doesn't seem like anything really happened there because they said we got to cut it off because the federal government said so. And then this is June 10th, and we'll talk about what discussions happened after June 10th.
All right. Now, regarding the 3 experts from ARCCA. So I've read that report. I can't tell who does what or what the basis of their opinion is. So what have you provided?
Your Honor, we've provided everything that we know. We've mentioned to this court at sidebar, these experts did not arise from us.
I understand that.
These experts were hired by the federal government, and they provided a report to us pursuant to the TUI request, and it was specifically outlined that and ruled that they could not prep with us for trial.
So
it was specifically outlined and ruled that they could not prep with us. I don't know by who. It doesn't sound like it's from Judge Cannone because she wants them to provide the Rule 14 discovery that they can't. So it seems like the federal government told them they couldn't prep with them. So they're not violating. It doesn't seem like if they did prep in violation of whatever that rule was, it doesn't seem like they violated a court order, which again changes kind of the sanctions available. So that's what I'm trying to figure out here.
TUI request, and it was specifically outlined that and ruled that they could not.
So pursuant to the TUI request, it was specifically outlined and ruled that they could not prep with us. Again, this is June 10th of 2024.
Prep with us for trial.
So I'm to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here
That's essentially it. We've spoken to them only for the purposes of coordination of their testimony and their background. That's it. We have not been able to interview them.
So coordination of their testimony and their background. I think I missed that the first time, but when you talk background with somebody, that can be pretty broad, right? So what do? Well, I look at cases like this. I do line of sight stuff. I do accident reconstruction like this case. So background and coordination of their testimony is more than just coordinating their schedules, So again, words are important. And when you get to stuff like this, the lawyers are going to have everything ready to argue what every single word means, that you did not lie to the court. You didn't misrepresent anything, that you did everything you said you were going to do when you said you were going to do it at the time you said it. That's important too here.
Regarding their findings, which are outlined in detail. We have not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides have.
So they were not able to talk to them about their findings. The judge is going to disagree that the reports are detailed.
See, I don't see that as being, the report, I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify to.
Well,
and you have not complied with your Rule 14 obligations.
We can't, Your Honor.
We can't. So you can't, but you haven't. So I am left with you haven't complied. So we need to get everybody here for voir dire. They can testify in a voir dire, right?
Yes.
We need to do that well in advance of their testimony.
Okay, that's fine, Your Honor.
All right.
Yep.
And now tell me about this ER doc. Is she an ER doc?
So first off, what did that sound like to you? Because to me, it sounded like we just solved all these problems. We have just cured all prejudices. Because as of June 10th, there has been no prep. There's been no email back and forth, no conversation. That happened June 22nd, according to Hank Brennan reading the emails. We don't know specifically what was in the outline or the notes, but that was June 22nd. So at this time, on this date, it seems like everything that was said was true. And any discussion, any issues, anything that happens after this is different than what happens here. And that's all really important.
I haven't seen.
Also, by the way, it's all been cured because they fix all of the discovery issues with the Rule 14 by the voir dire. That's how you take away any prejudicial effect so that the Commonwealth knows exactly what's going to be testified to and they can ask any question they want on cross. It is to cure the prejudicial effect. We saw it happen in Sarah Boone. We've seen this happen in many cases. Voir dire basically cures discovery issues.
She's not a pathologist,
Well,
correct?
she's a pathologist, but she has
They're talking about Russell just for a second, then they get back to ARCCA.
lot of experience in an ER, which is why she has the experience of having seen dog scratches and dog bites and dog attacks.
All right. So this is not somebody that was involved in the federal investigation, correct?
Correct.
All right. So you need to provide immediately. I want to, and we want the other folks up here from Pennsylvania this week as well.
Okay, well, we'll make those calls.
So we need to pick a day. How long do you expect the voir dire of each of these witnesses? If in fact the defense has not spoken to these witnesses from Pennsylvania about the nature of their opinion, you must want it too, to be able to question them. How long do you expect?
And prior to voir dire, we have nothing that says they've spoken to them, right? The email correspondence was after voir dire because he complimented Jackson's questions during the voir dire.
Expect the voir dire of each of these witnesses to take. I went and told the jury last week,
I'm sorry.
last week that we were going to get them this case by the end of the month based on your representations, which included voir dires. It looks like at least a day of voir dire hearings here.
Yeah.
Yes.
Of course, at least with regard to the ARCCA witnesses, that's my co-counsel's bailiwick. He anticipates that unless there are, a substantial number of objections during the voir dire, he anticipates being able to accomplish that between 45 minutes to an hour with each of those three. With regard to Dr. Russell, we anticipate a half hour. Oh, I'm sorry, there's only two from ARCCA, that's right.
You're only calling two? Which two? Are you calling the two that are certified as accident reconstructionists?
Doctors Rinchler and Wolf. Yes.
Mike goes out. Yannetti says something. Lally stands up and says something. Not sure what it is. I checked some other streams as well. But that's all we could hear from that hearing. So what this boils down to for me is there is some in the TUI letter rule that they cannot prep before their trial testimony. Then they come and do voir dire cold. Then after voir dire, there's some kind of conversation between, or at least email communication between Jackson and Wolf, where they do absolutely discuss something that has to do with this testimony. But this is after the state already got to voir dire Wolf. So they've cured all discovery issues. So then he comes and testifies. And then the trial's over. And now we're getting to trial 2. And pursuant to Rule 14, the defense has turned this stuff over. They've turned over the outline, the email, the comments back and forth. So there's no discovery violation for trial 2 because they've turned over everything, assuming it's everything, according to Rule 14. So there are two things that it boils down to. Number one, was there technically a discovery violation in trial 1? And I would say yes. If they had these email correspondence, they had these past outlines and notes of what the questions were going to be and his specific findings back and forth, and I can testify to this or not testify to that, regardless if he did or not, was there technically a discovery violation in trial 1? I think I would say yes. Was it material? Was it prejudicial? Did it matter? Would it have changed anything? Absolutely not. There should be no sanction. We saw the same thing happen in Sarah Boone's case. We've seen these types of discovery violations happen in many cases. We saw it happen I think we saw it happen in Baldwin's case, not where they ended up throwing out the case, but where it was fine and they were able to cure it. We've seen it happen in lots of cases and lots of trials. And when it's not material and it doesn't have a prejudicial effect, especially because you were able to voir dire these witnesses, it's a nothing burger. There shouldn't be any sanctions as far as the first trial goes. Now, the second and potentially bigger problem is the $23,000 bill. I don't know what that was for. I don't know who paid it. I don't know if the feds paid it. I don't know if the defense paid it. I don't know if the court's going to find that that's the same thing as, expert fees. In my perspective and in my practice, I always disclose and turn over what we pay for expert fees and cost reimbursement, travel expenses, everything, because in every jurisdiction I've ever tried a case in, that's all discoverable. That's all allowed for the other side to ask questions about bias. If you say you do things out of the goodness of your heart, or you did it for free, or you didn't pay them, but you paid them for costs, I do think there's a difference there, in my opinion. I think you do have to disclose that. So if they did pay $23,000 for trial number 1, because if it's for trial number 2, they turned it over. Pursuant to Rule 14, they turned it over if it's for trial number 2. But if it was for trial number 1 and they said they never paid them, is that going to be an issue? Now, there's all sorts of other details, and it depends. Did they pay them after the trial? Did they actually pay them nothing when they said they paid them nothing? And if it did and they paid them after, then technically it wasn't a violation, and really there shouldn't be any sanction because now they're telling them they did. And if they want to ask them about it in trial 2, they can. That's the distinction here. If they had paid them the $23,000 when they put them on the stand and they said, I've never paid you anything, and the witness said yes, that's a major issue and violation that could result in a sanction of the lawyer involved, which is Jackson, I believe. Yannetti was doing this argument, but I think that was all done by Jackson. By the way, none of this in any way, shape, or form do I see as a possible sanction for a discovery violation being striking these ARCCA witnesses. I see no way in which a judge could ever do that and prejudice a defense in this scenario based on these facts and what happened. Interesting notice, a little more context, watch the hearing together, continue to try to think about this, realize there are some important factors we don't know, but that's where we're at. So you guys let me know what you think in the comments. Make sure you hit that like button and are subscribed to our page. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the lawyer you know.